Hi, I'm Nadia McLeod from Emery Legal Kits. It's not always easy to work out if you are in a de facto relationship. So what does the term de facto relationship mean under Australian law? And how do you work out whether it applies to you? The first place to find an answer is the Family Law Act 1975. A de facto relationship is defined under Section 4AA of the Act as a relationship that two people who are not married or related by family have as a couple, living together on a genuine domestic basis. It can exist between two people of the opposite sex or between two people of the same sex. Your relationship is not a de facto relationship if you are legally married to each other or if you are related by family. All the circumstances of your relationship influence whether you would be considered a de facto couple or not. And these can include factors like the nature and extent of the common residence, the ownership, use and acquisition of any property, whether a sexual relationship exists, the degree of financial dependence or interdependence, and any arrangements for financial support of one and other. To see all the factors and look at some real-life examples, go to our article, What is a de facto relationship? At financialagreements.com.au. You can follow the link in the description below.